San Bernardino County School Boards Association is proud to partner with County Superintendent of Schools and the Inland Personnel Council to bring you this series of workshops on effective boardmanship. Hello, my name is Mary Sandoval, your San Bernardino County Association President and a board member for Fontana Unified. The Brown Act is intended to guard against backroom deals. The law helps ensure that the important work of public schools governance is conducted openly and transparently. There are a few exceptions that allow school boards to meet behind closed doors, but even there, safeguards are supposed to be in place. Ignoring these rules can lead to a variety of consequences based on the severity of the violation.
Good evening. I'm Ted Alejandre, your San Bernardino County Superintendent of Schools. Welcome to this, the third in a series of effective boardmanship workshops. I'm holding a gavel, which is a tool and a symbol that school boards use to convene meetings and conduct business. The Open Meeting Law, or Brown Act, has requirements that may not sound exciting, but in fact, this is one of those topics that carries an important duty for all board members to follow. We have two top-notch attorneys here to guide us through the process, courtesy of our partners at the Inland Personnel Council through Atkinson, Andelson, Loya, Rude, and Romo. Brooke Jimenez represents California Public School and Community College Districts and County Offices of Education in the areas of education law, employee discipline, harassment and discrimination complaints, and contract administration. She also handles general litigation matters, including discovery, depositions, mediations, and appeals. Todd Robbins represents public school districts in the areas of education law, certificated and classified employee discipline, certificated layoffs, harassment and discrimination complaints, and contract administration. He also advises school districts on matters relating to the California Voting Rights Act. He has guided several school districts through transitioning from at-large elections to by-trustee area elections. With that, let me turn the gavel over to our attorneys for the presentation.
Good evening. Thanks for having us. Today we're going to talk about topics in boardsmanship. This is an important topic for all board members. It's especially important for newer board members who may not have experience with the Brown Act. It's been a weird little bit of a year here, so this is a good opportunity for you to get some training in the Brown Act, the formal processes, especially now that we're all back in person at board meetings. So we're going to cover a range of topics. Brooke and I will be going back and forth with various topics today, and at the end there's going to be an interactive Q&A session where there will be questions that were submitted by board members and also created by us to help inform some of the topics that we discussed today. So with that, I'm going to pass it over to Brooke to get started.
So the purpose of the Brown Act is to ensure that public agencies' business is conducted out in the open for transparency purposes. The rule essentially is that all meetings of a legislative body be open and public to the public, and all persons be permitted to attend any meeting of the legislative body or of a local agency. So what is a legislative body? That includes the Board of Education, that includes any standing committees, that includes any ad hoc committees that are appointed by the board. What does not include less than quorum subcommittees of the board or committees that are appointed by the superintendent. And so then what is a meeting? So a meeting is a congregation of a majority of the members of the board, no matter how informal, at the same time and in the same location, which includes a teleconference location, as many boards have been doing over the last year and a half, to hear, discuss, deliberate, or take action on any item that's within the subject matter jurisdiction of the board. Deliberate will include any collective acquisition and exchange of facts and information preliminary to making an ultimate decision. And then, of course, action taken is any collective decision by a majority of the board, commitment or promise by a majority of the board to make a positive or negative decision, or an actual vote of the legislative body. Okay, so the definition of what is a meeting shall be construed very broadly under the Brown Act, and that includes any study sessions, even discussions amongst the board members, informal sessions, as well as a serial meeting. And we'll go through our exercise on what is a serial meeting and how to make sure boards avoid a serial meeting. Okay, so serial meeting, many board members are familiar with this phrase. But the exercise will help us actually determine what is and what is not allowed in terms of board communication. So a serial meeting is a majority of the members of the legislative body meeting outside of an authorized meeting. So that is prohibited, as well as any series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item within the board's jurisdiction. What is not a serial meeting? So what's not a serial meeting are any separate conversations or communications outside of a meeting to answer questions or simply to provide information regarding a matter within the jurisdiction of the board. If the person does not communicate the comments or position of any other board members to the other members of the legislative body. So the concepts themselves may sound very convoluted, but it's best to kind of go through the exercise to determine what is and what is not a serial meeting, and what is and what is not allowed in terms of communications. Okay, so our first exercise would be member 1 has a conversation with member 2 about a particular item within the board's jurisdiction. Then member 2 speaks with member 3, member 3 speaks with member 4. Ultimately, the information is being now relayed to member 5, the 5th member of the board. So now we have a majority of the board, all board members in fact, talking about a particular item where member 1's information is shared all the way down to member 5. This is the best, clearest example of a serial meeting, which is prohibited by the Brown Act.
So even in this example, Brooke, would you say that with the board not taking action, that's still a serial meeting?
Yes, definitely. So a meeting would include even just the sharing of information, any discussion, preliminary discussions, even when board action is not actually taken. Another example, which is slightly different than the first one, where it'll be member 1 is communicating separately to member 2, 3, and 4, similar to the first example. However, the other members are not communicating with each other. So member 2 is keeping the information provided by member 1, as well as member 3 is keeping that information, and member 5 is left out of the conversation completely. And so this is not an example of a serial meeting, because the information is one way and there's no sharing of information amongst the board members, amongst the majority of the board members, to create a collective agreement or decision on any matter within the jurisdiction of the board. A next example would be the superintendent or someone in the superintendent's office communicating one way with each of the board members. So we do definitely have a quorum. We have communication going to the board, but here again, similar to the last example, there is no decisions being made. There's no information being shared between the board members, so that each board member would not know what the other board members are deciding on a particular issue.
So I've heard this type of example sometimes referred to as the hub and spoke example. You have the superintendent as the hub in the middle, and the spokes are the information going out to each individual board member but not being shared around. Is
Yes.
that similar to your experience?
Definitely. And a good example of this would be the superintendent's office communicating with the members of the board on scheduling issues, things of that nature, just providing them information where a collective agreement or decision is not being made. So now let's look at the slightly differentiation of the hub and spoke model. Now we have members, member 5 communicating with member 1 and member 4 on a particular issue based upon the information provided by the superintendent's office. So now we have, amongst 5 members, we have 3 that are sharing information, which then, would become a violation of the Brown Act, because this is a serial meeting. If member 5 discusses their thoughts with member 1 and member 4. So now there may be a collective agreement amongst the 3 board members. And here again, this looks very similar, but when you look actually at the circumstances here, they're slightly different. So superintendent communicates with member 1. Member 1 then communicates back to the superintendent. So the superintendent has some sort of understanding of member 1's stance on a particular issue. Similarly, with member 4, superintendent provides information, member 4 provides back to the superintendent, and then separately, member 2 and 3, or member 2 provides their thoughts to member 3 on a particular issue. This may appear at first to look like a serial meeting, but in fact, there isn't a quorum of members coming upon a collective decision, and so this would not be an example of a serial meeting. Okay, so now that we've gone through all of those examples, there's many, many more, but you can imagine situations that come about where board members are communicating in different forums on matters within their jurisdiction. So just as in terms of a legislative update related to social media, which has gotten some board members into some sort of questionable trouble in recent years concerning their actions on social media, which most members believe to be private or personal, but members of the public may perceive to be public and actions of the board itself. So AB 992 was signed into law September 18th, 2020, and amended the government code, the Brown Act, which to address specifically social media use by the board. So certain communications involving a legislative body's members on social media platform may not constitute a meeting under the Brown Act, but under the Assembly Bill, a legislative body's members may engage in separate communications on social media to answer questions, to provide information to the public, or to solicit input from the public on matters within the board's jurisdiction. So it's okay to answer questions, provide information, and receive information via social media. However, what's not permitted and was fleshed out more under the Assembly Bill is that a majority of the legislative body may not discuss amongst themselves the business of a specific nature within their jurisdiction. So on the social media platform, they are not to have conversations where they collectively come to a decision or they discuss their stance on a particular issue within their jurisdiction. This would encompass any communications made, posted, or shared on social media between members of the board, any comments or use of a digital icon, for instance, the like button, that express reactions to communications made by members of the board. So for instance, a board member posts something on their social media page, other board members are liking that comment or maybe disliking the comment or adding some comments in response to that. That would be prohibited under the Assembly Bill. Additionally, individual trustees may not directly respond on social media to anything posted or shared by another member of the board regarding a matter within the board's jurisdiction. Before Assembly Bill 992, a single contact between one board member and another board member would not constitute a serial meeting. However, now if one public official does post a comment in response to another public official, another board member's social media post, this could violate the Brown Act. So there's a slight distinction there. Even though it's only 2 members involved, one person posts and the other person comments or likes or responds in some way, that is likely a violation of the Brown Act now under the new Assembly Bill. So the lesson is that board members need to be extra cautious when using social media, especially when discussing or expressing their opinions on items within the board's jurisdiction.
And what's interesting with this as well is that even things that are celebrating the school district, if there's, accomplishments at a school or, such and such high school just got a golden bell or a distinguished school, the board members commenting on that to celebrate or to say we should do X, Y, and Z in response to this, that could constitute a Brown Act violation now under this change in the law. So it's important that our friends be mindful of that, because it's really easy to want to participate in an exciting and happy conversation, and we just have to be mindful that that can create problems now under the Brown Act.
Okay, so next example, just to kind of help nail this down, is at a CSBA workshop as part of the official program, a majority of board members speak about the district's takeover by a state trustee. That's A. B, all 5 board members attend a welcome reception for a new administrator, and each one tells the administrator about their biggest pet peeve. C, 3 of the 5 board members show up at a city council meeting. They talk about a pending student disciplinary matter while waiting for the meeting to begin. And D, 3 of 5 board members show up at a planning commission meeting. Each speaks out during the public comment time about the need for a school to be located in the community. So which of these violates the Brown Act?
And these are good hypotheticals because there's a lot of nuance in each one of them, and I think there's key phrases in each one of them that are important to pay attention to. CSBA always creates a lot of questions about what can we talk about while we're there, can we be in the same room together, but there actually is a carve-out for these statewide conferences where members of the public may be allowed to attend, but also where they're speaking as part of an official program. That takes it outside of the Brown Act. The next one is interesting because they all attend a reception, and it could be, there's a carve-out for ceremonial events and things like that, so perhaps this is a ceremonial event, and each administrator tells or each board member rather, tells the administrator about their biggest pet peeve. I'm fairly certain that pet peeves are not within the subject matter jurisdiction of the board, but if it involves a pet peeve related to the school district, perhaps it could trigger that. Letter C, 3 of the 5 show up at a city council meeting. I think it's important to note that there are Brown Act carve-outs for people to attend public meetings, even when they are board members, as long as those meetings are open to the public. But again, these hypotheticals have nuance in them, and it's that second sentence or that second part of the hypothetical that's really important here is the 3 board members who are at a noticed and open public meeting, which is allowed, begin to talk school business outside of the purview of that open and noticed meeting. It's not within any context related to that meeting. So I think that letter C is probably the problematic one. Letter D is another open and noticed public meeting, but the board members speak out during public comment, and there are some exceptions for that. So if I had to guess, I would say letter C, the 3 board members at a city council meeting and talking about a student discipline matter is the problem. Yes.
So again, we wanted to create hypotheticals that were close to real life situations, and paying attention specifically to the phrasing and the specific circumstances is really important. So yes, C is a violation of the Brown Act, even though 3 of the board members are attending a city council meeting, which is an open public meeting. It's a city meeting and not a board meeting, and it's likely that the student disciplinary matter is not on the agenda for the city council meeting, so the discussion of that amongst the 3 board members would constitute a serial meeting under the Brown Act.
So there were some unique carve-outs that were created as a result of the pandemic that actually created some exceptions to the serial meeting issue and to the meeting limitations that are within the Brown Act. So Executive Order N3520 allowed board members to receive updates at the same time relevant to the COVID emergency from federal, state, and local officials without having to agendize a meeting. They were also allowed at those perhaps impromptu or shortly noticed meetings. They were allowed to ask questions of the officials that were giving the presentations in order to stay up to date about what was going on in the emergency. And this was really relevant in March of 2020 when things were just changing so rapidly. School districts were closing down. We were getting updates from the state and from the county, sometimes hourly, and so it was a good executive order to allow board members to be getting that information without having to have administration get that information and then pass it along to board members. It didn't allow the board to take any action or discuss amongst themselves any other items that were within the subject matter jurisdiction of the legislative body, so the board would still need to call a meeting in order to take action on the information that they received, but they were allowed to be active participants in receiving that information. So this is an executive order that will ultimately expire with the coming September 30th expiration of executive orders, but it was something that did create an exception. All right, so with respect to agendas, the agenda is really the most important document that's guiding what's going to be happening at your meeting. And there are specific requirements that school districts have to follow and other legislative bodies have to follow with respect to agendas. And so there are really two common types of meetings. There's a regular board meeting and there's a special board meeting. Your agendas need to be posted 72 hours prior to a regular meeting and 24 hours prior to a special meeting. In an emergency situation, which we were actually dealing with in March of 2020, the posting requirement is reduced all the way down to 1 hour. And there are some specific requirements for posting for an emergency meeting. You have to contact local media to let them know that we're having an emergency meeting. If you have a local radio station in the community, you would need to contact that local radio station so the information could be shared over the air. So we were actually taking advantage of that emergency meeting provision back when schools were shutting down in the spring of 2020. Under the default circumstances, teleconferencing is allowed for school board members to attend a board meeting via teleconference. The agenda needs to reflect where an individual board member is teleconferencing from, and that needs to be so specific as if you're staying at the Grand Californian, for example, at Disneyland, you would need to put the fact that you will be attending the meeting from the Grand Californian Hotel at Disneyland, and you will need to put the specific room where you will be attending from, so that the meeting could be open to the public that is at the hotel there with you and would allow them to participate in public comment. Those teleconferencing requirements were suspended by Executive Order N2920, which will expire on September 30th as well. And those teleconferencing requirements were suspended so that boards could continue to conduct business during the pandemic in a safe way, without the kind of unreasonable expectation that board members open their homes for public comment while unsafe public health conditions existed. So that's why that executive order was created. But it's important to keep in mind that that is expiring, so it's good to get your Brown Act legs back underneath you to remember that if you are going to attend by teleconference, it's important that you follow the requirements of the Brown Act. With respect to what the agenda has to say, it's important to remember that the agenda items need to reasonably apprise the public of the business to be transacted. So that it gives the public the opportunity to review the agenda and decide, am I going to show up and make a public comment or listen to what the board's discussion is? It doesn't need to be a novel-length description. It just needs to be a brief description that is clear and concise, usually no more than about 20 words. And then any materials that are provided to the board with the agenda become public records almost immediately. As soon as they're given to the board, the public can have access to those records, unless they're confidential records that would be under the closed session agenda items. Special meetings, I mentioned them earlier. They are a type of meeting that can be called either by the president of the board or a majority of the board. These meetings typically involve business that comes up that is urgent but is not an emergency. Other school boards may use a special meeting for the purpose of having a study session, for example, where they learn about a particular topic or where they discuss LCAP information. But these types of agendas need to be posted no later than 24 hours before the board meeting is going to start. And anybody that's requested the information to be sent to them, any members of the community that have requested agendas to be sent to them via email or regular mail, those need to be in their hands no later than 24 hours before the board meeting starts. The board can only consider business that's specified on the notice of special meeting, and there are limited public comment options at special meetings, meaning that the public can only comment on the items that are on the special meeting agenda, which is different than the regular meeting agenda where they have a little bit broader scope in what they can discuss. It's okay to have a closed session during a special meeting. In fact, there may be reasons why a special meeting is called only to have a closed session. It may be an urgent personnel matter that occurs. There may be an urgent property matter that they need to deal with. And so it is common for school boards to call a special meeting just to hold a closed session. But it's important to remember that the Brown Act was amended several years ago to prohibit special meetings from being called for the purpose of discussing the salary or benefits or other compensation in the form of fringe benefits of any local agency executive. So you could not call a special meeting to discuss contract amendments for cabinet level officials in the district. You could not call a special meeting to talk about the salary that you're going to offer a new superintendent candidate. Those types of discussions have to take place at a regular board meeting, and it's because the legislature found that there was some abuse taking place in that context at special board meetings. Board meetings have to be ADA compliant, so if there's an individual that needs an accommodation, the board is required to make an accommodation for that individual. The most common would be providing a sign language interpreter for an individual. And so if an individual does request an accommodation, it's good to make those accommodations, and if there's a question about how you can make those accommodations or whether you should make those accommodations, it's important to call legal counsel to talk about what your obligations are under the ADA and also under the Brown Act. Meetings need to be held within district boundaries. This is a change for those of you who are new board members who may have been attending remotely from different locations because you were able to Zoom into the meeting. But normally, board meetings have to be conducted and a quorum of the board needs to be within the boundaries of the district. So once the executive order expires on September 30th, those default requirements will go back. There are a few exceptions. One of the most common exceptions may be where a board travels to a different location to meet with and interview a potential candidate for employment with the district. If they're going to do a site visit for a superintendent, the board may meet outside of the district boundaries for that purpose, but your agenda has to specify where you will be going and there has to be certain requirements met. We frequently get asked, can an individual of the public, member of the public, Facebook Live the board meeting? And the answer to that question is yes. The Brown Act specifically says individuals can record either through audio recording, video recording, take photographs of a public meeting, but it's important that what they're doing does not cause a disruption. So those individuals should not be walking to the front of the room and blocking the audience to try to get a close-up of a board member discussing a particular item. They shouldn't have big light stands that cause people to have to strain to see the board. So it is okay for individuals to photograph, record, video, or audio a board meeting. We did talk about the executive order N29-20, which suspended the in-person requirements for attending a board meeting. The boards under that executive order were allowed to conduct their meetings virtually so long as there was an opportunity for public comment. And the language in the executive order was that the meetings needed to be accessible telephonically or otherwise electronically. So a lot of school districts started holding their meetings over Zoom. Others already had the infrastructure to use their boardroom to broadcast the meeting with a limited presence within that room. But the requirements for physical presence at the board meeting were suspended. So frequently the boards were meeting and each individual member was at their home or at a remote location. With respect to the virtual board meetings, which again, September 30th are expiring, but it's important to talk about what exceptions were created. We did discuss that the public was, we needed to require that the public had the opportunity to observe and address the board either telephonically or through some other electronic means. And there's a whole range of how boards were handling that, from call-in lines to Zoom opportunities to submitting emails to be read into the record. None of those methods were ever challenged ultimately in court and found to be insufficient, but we did get a lot of inquiries from the ACLU, for example, and also sometimes from community members asking the board perhaps to do more if a board wasn't necessarily allowing for video public comment, for example. So, but again, all of those things are expiring September 30th. As we'll discuss a little bit later on in the presentation, there are some potential legislative changes coming down the road, but none of them have been signed into law yet. So it's unclear what the state of play is going to be after September 30th when it comes to these types of virtual board meeting attendance. With respect to meeting conduct, there's some real basic things to remember. The board calls to order the meeting, and then one of the first actions that the board takes before they do anything else is that they approve the agenda. And during the agenda approval, there may be a discussion to pull an item from the agenda for a whole slew of reasons. It could be that there's a typographical error in a dollar figure that's on there and it's too late to fix it. It could be that the circumstances have changed and the board doesn't want to discuss it at that meeting, may want to move it to a later meeting. This is also a time where you see board members ask if they can pull items from the consent agenda for individual discussion. And so this all happens at the front end of the meeting. There are very limited opportunities to add to the agenda. However, those opportunities are limited only to actual emergencies. So where there's an immediate need to add something to the agenda. And you have to think about this in terms of the item needing to go on the agenda or something detrimental is going to happen to the district. Either they're going to lose an opportunity to purchase some real estate that they only received very short notice that it was available to them, or some other contingency arises. You can amend the agenda prior to a board meeting and after the agenda has been posted, but we would strongly recommend that you contact legal counsel to make sure that it kind of meets that standard. And in order to amend that agenda, it's going to require a 2/3 vote of the board. And so if you have a 5-member board, 3 board members isn't going to cut it. That's only 60%. So you're going to need 4 of the 5 board members to approve that change. Unfortunately, forgetting to put something on the agenda is not an emergency that is sufficient to give rise to this opportunity to amend the agenda. But again, the cases are individual in nature, so if you have a question, contact your legal counsel to see if it's appropriate to amend the agenda. And then with respect to conduct, there is a requirement after closed session to report any action taken and the vote of each board member. Board meetings must include public comment opportunities before the board takes action. So if you have a closed session agenda that's at the front of your board meeting, you do need to have an opportunity for public comment prior to going into closed session. and then we would recommend that you have a second opportunity for public comment before you begin consideration and discussion on open session items. When you're talking about what can the public comment on at a regular meeting versus a special meeting, at a regular meeting, the public can comment on any item that's within the subject matter jurisdiction of the board. So even if a topic is not on the agenda at a regular board meeting, a member of the public can come and speak on any item that's within the subject matter jurisdiction of the board, and that's okay. However, at a special meeting, it is limited to only the items that are on the agenda. So if a member of the public comes to discuss the ASB program at the local high school, and that's not what's on the agenda for the special meeting, that would not be an appropriate public comment for that special meeting. And that member of the public should be encouraged to come to a regular meeting to make that comment. Boards are required to take minutes of their actions. These do not need to be a verbatim recitation of everything that happens at the board meeting. The minutes can just be a brief summary of what was discussed, and then what action was taken by the board. And the minutes will need to reflect, who voted yay or nay if it was not a unanimous decision. Obviously, there's no secret ballots, so boards. The intent of the Brown Act is to conduct your business in open, in front of the public. So secret ballots run contrary to that intent of the Brown Act. You have an obligation to report the vote of each trustee present, and that would also include an abstention. And a lot of boards have transitioned to electronic vote recording systems, and so they'll push a button, and then the screen will reflect that board member Jimenez voted yes, board member Robbins voted no, and then if you're abstaining for one of the limited reasons that a board member can abstain, which are usually defined by board bylaws, it would reflect that the abstention was on there as well, and that would all be captured in the minutes, so long as the recording system captured that information, and if it didn't, then the recording clerk would need to capture that information and include it in the minutes. With respect to public comment, it's subject to reasonable regulation. So a typical regulation on public comment is that individuals are afforded 3 minutes to make a public comment. If there's a group of individuals that want to speak on one topic, a typical regulation is that group is afforded 20 minutes to speak on a topic. If an individual does not speak English, we would be required to provide a translator. And so if we're using that hypothetical 3-minute maximum for public comment, that individual who requires a translator would be afforded up to 6 minutes to make their comments. And that's a relatively recent change to the Brown Act. And then one of the more challenging things that boards encounter is when a member of the public comes and makes a public comment and makes disparaging remarks about a member of the staff, or perhaps the superintendent or a teacher. The board cannot prohibit criticism of employees, nor can it prohibit criticism of the district or of board members. There's a case out of the California Court of Appeal called the Baca versus Moreno Valley decision, and that solidified the idea that an individual is allowed to come and complain and make disparaging comments about the employees of the district, and the board can't limit that from happening. You can direct that individual towards the district's complaint procedures. So if you get an individual that submits a public comment and they put on there that they want to discuss, their concerns about a particular teacher or classified employee, there's nothing wrong with meeting with that individual prior to the public comment opportunity, just to say, hey, we weren't sure if you knew that we had a complaint process. Here's the complaint process. And that may diffuse the situation. The individual may be satisfied with getting the complaint process in their hands so that they can formalize the complaint. But they still may want to make a public comment where they air their concerns about a particular employee. And that's okay. They should be allowed to do that. It's also okay to remind them that there are privacy and defamation laws that may come into play if an individual feels like they've been defamed or if there's been an invasion of privacy based on a comment made at a board meeting. There's not total immunity for members of the public from defamation laws. And so it's important to remind them of that. And I do know some boards in their description of the public comment item on their agenda, when they're reading it out at the meeting, do explain that members of the public can be subject to claims of defamation based on public comments they make. So it's just good to remind people of that. The Brown Act does limit what a board member can say in response to a public comment. So board members should not respond if the item that the member of the public is speaking on is not on the agenda. The only thing a board member can do in that particular situation is to direct that member of the public to the relevant staff who could handle the situation. And frequently what we're seeing is a lot of individuals will come to talk about their concerns about special education in the district. So they've said their piece in their 3 minutes or their 5 minutes at the dais, or at the podium rather. And at the end of that comment, the board president may say, "Thank you for your comment. Please go see so-and-so, the director of special education, and he or she can help with the concerns that you raised." That's fine, but it's not okay under the Brown Act to engage in a back and forth dialogue with that individual after their public comment. Specific matters of district business should not be discussed during public comment if it's not on the agenda. It's just important to remember that. There's an urge to respond, but the Brown Act does limit what types of interactions you can have during public comment. So to kind of flesh this out a little bit more, during public comment, trustees and staff may only briefly respond to statements made or questions posed by the person making the public comments. And typically that's a "thank you for your concern. Please go and speak with Mr. or Mrs. So-and-so about your concern." And that's fine. It's also fine to ask limited clarifying questions. So if you are uncertain as a board member what that individual member of the public is talking about, but it does sound like there may be a legitimate concern there, and in order to expeditiously address that concern, you want to know which staff member you should direct them to, you can ask a clarifying question. You know, are you talking about a facilities issue, ma'am, or are you talking about a staffing issue? Obviously, the answer to that question is going to, determine whether you refer them to the assistant superintendent of HR or the assistant superintendent of business to address the facilities issue. Again, you can provide the member of the public with reference to a staff member or perhaps to your website for other factual information. So if they make a statement, for example, they say, "I've never seen your COVID safety plan." If you know exactly where to point them to after they make that comment, it's okay to say, "Sir, ma'am, you can go to our website and click on the parent resources, and right there is access to our COVID safety plan." That type of comment in response is sufficient, and it's allowable under the Brown Act. And it's also okay to request that the staff that you're asking to address a concern to report back to the board at a future opportunity or to place that matter on the agenda for a future meeting. Those things are allowed under Government Code Section 54954.2. Unfortunately, sometimes board meetings have to deal with disruptions. We're seeing that a little bit more frequently as we reopen the 21-22 school year. And so when you have a disruption occur at a board meeting, the Brown Act does provide you with some tools. Typically what we recommend if there are disruptions happening at board meetings is that you first try to address it at the lowest level possible. So if you have a disruption occurring and you have security there, perhaps there's some predetermined sign that you will develop or that the superintendent has with security to perhaps go and speak to that person that's causing a disruption. If that doesn't work, then the board president can specifically address that person and warn them that if the disruption continues, that person may be removed from the meeting. And then if the disruption continues, you can have an individual or a group removed from a board meeting, but just keep in mind that that does create, concerns, the political concerns being one of them, and also, the media who may be reporting on the board meeting may not clearly explain why that individual or why that group was removed. So think of that as an option of last resort, but if it does need to happen, it's important to have security or law enforcement assist with that removal. And one of the ways to accomplish the removal that you have available to you is you may clear the room. So the board president, if the disruption is substantial enough, the board president can clear the room. We're taking a recess, we're clearing the room, everybody needs to go out into the parking lot to cool down. And if the board president determines that we can reconvene the meeting after that room has been cleared, if there's media that is present at the board meeting and they're not being disruptive, they need to be allowed to remain and attend for the remainder of the meeting. Additionally, the circumstances may create an unsafe environment and you can retreat into the closed session room, but again, you'd want to announce from the dais that the disruption has become unmanageable and that the board is retreating to closed session until the disruption is addressed. And then in the worst case scenario, you can adjourn the meeting and reconvene to a later date. Fortunately, we haven't had to reach that point so far this year. I personally haven't. Have you, Brooke, had to deal with that situation?
No.
But I do know that meetings have been disrupted and that individuals and groups have been asked to leave the meeting. Yeah. And so it's unfortunate, but it is happening at this time. We recommend that if you anticipate a disruption, that you work with legal counsel, have your superintendent and board president work with legal counsel so that you have protocols in front of you, so that you have a script that you can read, because there are penal code sections that are helpful to you. There are education code sections that are helpful to you that justify the ability to clear the room if necessary. And then obviously the Brown Act specifically does allow for disruptions to be dealt with in this way.
Yeah, so I've noticed that as of late, many boards have put a script or prompt on the agenda discussing the rules for public comment and public attendance, as well as their ability to remove disruptions from the board meetings right within the agenda. And that's been helpful to just notify the public that here's what I need to follow if I'm going to attend this board meeting. Here's what's going to happen to me if I end up causing a disruption. And then also board presidents will, at the beginning of a meeting, make a statement or a script that they've worked with legal counsel to prepare to let everybody know the expectations for attending the board meeting.
And I think that notice point is really important. One of the biggest catalysts for disruption has been the mask issue. And so boards have been putting signs outside of the board meeting, masks required, on their agendas that masks are required. So any issue, anytime you can give more notice in advance, it's going to help you on the back end if you end up having to remove, because then you can point to the signs out in front of the building, or you can point to the language on the agenda that says we put the public on notice that these are the expectations for attendance, and you're not in compliance with those, so we're going to need to have you removed. And it's never easy. And unfortunately, it's usually not handled very accurately within the newspaper reports that come out the next day, though I do have to compliment one newspaper that I saw in one of our San Bernardino County districts did actually do a really good job of just stating the facts of what happened and not really editorializing on it. And so that was good. But it's really important that you don't remove somebody because of the content of their speech. So if somebody is getting up and saying, and they're operating within the normal public comment process and saying at the podium, board, we really disagree with your decision to require masks of students. We think that it's unfair and that it's bad for kids. If you were to gavel them down and have them removed from the meeting because of the content of what they were saying at the time, that would be problematic, and that would likely lead to a potential First Amendment challenge and some other consequences. So if you're thinking about disruptions, what you're thinking about is a disruption in the board's ability to conduct its business. So if you are getting to an item and that item comes up and the audience begins to talk and scream and yell and march, and you're not able to discuss that item as a board because the noise is overwhelming and you just can't get a word out edgewise, that's a disruption. It's prohibiting you from conducting your business as a board. Mm-hmm. But you can't kick somebody out of a board meeting because you disagree with what they're saying if they are complying with the other regulations for conducting the board's business. All right, so we have a hypothetical about a public comment situation, and the ultimate question is, has this board violated the Brown Act? So here are the facts. During a board meeting, an employee submits a public comment card. When public comment time arises, the employee is advised that she has 3 minutes to make her comments consistent with the board bylaws. The employee begins asserting numerous allegations against a supervisor, claiming discrimination and harassment, and asserting that her recent letter of reprimand was issued in retaliation of her challenging her supervisor's ridiculous instructions. So before I go on, Brooke, that comment there is allowed for public comment, correct? She can criticize her supervisor,
yes,
right?
Correct.
Yeah. So next, the two of the board members asked the employee to provide specific examples of the abuse she had suffered. One board member vows to personally investigate the allegations to make sure the employee is protected, and the other board members all agree with this approach. The discussion between the employee and the board lasts 9 minutes. So again, the question is, has this board violated the Brown Act? And the answer to the question is yes. Board members requesting specific details about the employee's complaint likely violates that Government Code section 54954.2, which limits what the board is allowed to say in response to public comments. That particular personnel item was not on the agenda, so it's not something that the board can have just an unfettered discussion about. The board's failure to direct the employee to the appropriate individual or department to address the concern may also violate that Government Code section. Similarly, the board's failure to limit the public comment to 3 minutes likely violates the district's board bylaw prescribing time limitations on public comments, and also the vow to investigate the employee's concern, that individual board members promise to investigate, and the agreement from other board members also likely violates the Brown Act, because the agreement from the other board members is an action that the board took at that point. And if that action was not on the agenda, it's not appropriate. And that individual board member's promise to investigate likely violates what is a very common board bylaw in school districts that requires the board as a collective, but also individual board members, to refrain from performing management functions that are the responsibility of the administration. And we'll talk about that in a little bit, about just kind of what is the role of a board member. But there are numerous concerns here, three of which directly address the Brown Act, but then others which implicate board bylaws.
Okay, so now let's talk about closed session. So we often get lots of questions about what can we talk about in closed session? Can we add something to the closed session agenda for this particular item? So let's talk about what the Brown Act has to say. So all meetings actually must occur before the public. So the default is open session unless the Brown Act specifically allows for a closed session, and it's based upon the particular content of the item that's going to be discussed. So Government Code section 54954.5 provides a whole list of safe harbor agenda language that many districts will use on their agenda for closed session specifically, and it provides the parameters of what items can be discussed in closed session. That includes conference with real property negotiators, conference with legal counsel, discussion of liability claims, threat to public services or facilities, employment type matters, including evaluations, appointment, public employee discipline, dismissal, release, and conference with labor negotiators. Many boards also use what we call the super secret EERA provision, which is set forth in Government Code Section 3549.1 of the EERA, which actually exempts from the Brown Act discussions between the appointed negotiations, team and the board related to the position taken in negotiations, as well as to receive instruction from the board in relation to the negotiations that's going on. So there's also the conference with labor negotiators within the Brown Act in closed session, but there's also an exemption from the Brown Act for negotiations type conversations with the bargaining team.
So I think the practical application of that super secret EERA provision is, you've had just a lengthy negotiation season. It's been contentious, it's been hard. The board has established parameters for the district to stay within, and you're reaching the point, your negotiations team is reaching the point where they're saying, we're close to impasse. But the union comes with a proposal that is really close to your parameters, but is a little bit above. And it's 7:30 at night, everybody's exhausted, they don't want to go to impasse. Under this super secret EERA provision, could the negotiations team step out into a caucus and get the entire board on a conference call to discuss that proposal from the union and get direction from the board as to whether they can agree to that provision or not?
Yes, that's the purpose of that. Is there are certain circumstances where waiting for the next board meeting to occur is insufficient, or we really need to get this deal because we're on the verge of impasse. And so having that discussion under this EERA provision is going to help kind of resolve the negotiations or move it along. Other than that, it's expected that boards put the item for conference with labor negotiator on the agenda and just have regular updates in closed session. But the EERA provision is for those specific circumstances where you just can't do it, you're in between board meetings, or you're really close to getting the deal, or really close to going into impasse, and so you need some instruction from your board. Okay, so closed session you must report and record the individual votes of each board member when reconvening into open session after taking action in closed session. Any vote on employment contracts must be made in open session in a regular meeting, and Todd talked about that before. No special meetings for these type of votes. The votes must occur in open session rather than in closed. The board must orally report a summary of any recommendation for compensation and benefits for any executive contracts in open session before voting on that contract. There cannot be discussion or action on any salaries or benefits in closed session related to executive members or employees, however, except for conference with labor negotiators. So if the board in closed session is going to approve or provide parameters on a salary increase for their CSEA or their teaching staff members, that can be done under the conference with labor negotiators in closed session. No special meetings regarding executive compensation or benefits, and we touched upon that before. Any discussion concerning executive compensation or benefits must occur in open session in a regular meeting, as said. And the agenda must be posted on the district's webpage, and so many of you will see there's specific heading for closed session items. It has the safe harbor language that complies with the Brown Act, and where necessary, we'll have some more specifics in terms of specifically we'll talk about anticipated litigation, what needs to be placed on the agenda item for closed session.
One important clarification as it relates to executive contracts is that the board under conference with labor negotiator, unrepresented employee, can discuss the potential terms that are going to be offered to a superintendent candidate, for example, or an assistant superintendent candidate. They can have that discussion in closed session, and typically if it's a superintendent search, it'll be the search firm discuss, that will be the negotiator for the candidate, and then the district's legal counsel may be in closed session as well. But the board can't approve that contract. So they could reach an agreement and say, okay, this is what we are comfortable offering the candidate. But that approval has to happen in open session. And you heard Brooke say that prior to approval, there has to be an oral report on the compensation and fringe benefits prior to the board discussing and taking action on that. And so that is a safeguard that the legislature has recently built into the Brown Act to make sure that those discussions that happen in closed session do get the light of day shed on them prior to the board actually taking action, so that the contract doesn't become official before the public gets kind of a real sense of what's in it from a compensation perspective. So it is important to note that you can have a conversation in closed session under conference with labor negotiator, unrepresented employee about an executive contract, but you can't approve the contract in closed session.
So next question is who can attend closed session? Who gets to go behind the closed doors? So there's nothing in the Brown Act that limits who the board may include in a closed session matter when they go into the other closed session room. However, the general rule is that closed session access is permitted only to people who have an official or essential role to play in the closed meeting. So that typically would include, of course, the board, maybe some executive cabinet members who are going to speak on a particular item in closed session. For instance, maybe the assistant superintendent of personnel who will talk about some employment evaluations or disciplinary matters. Legal counsel, if there's something on the agenda for anticipated litigation or something of that matter, they will typically attend closed session as well. So with respect to personnel matters, a local legislative body may meet in closed session to consider the appointment, employment, and evaluation, discipline, or dismissal of an employee. That's all covered under the Brown Act. The discussion must relate to a particular individual, so a particular employee. It's not just a broad, open-ended type agenda item for any individual. However, before meeting in closed session to hear specific complaints or charges against an employee, that employee who is subject to the complaint or charge must be provided some 24-hour written notice prior to the meeting that advises that employee that they have a right to have the complaints or charges against them heard by the board in open session rather than in closed session. So the right is for the individual to bring to the light what they would normally discuss in closed session. We get many questions from boards saying, we have this employee that matters on our agenda for this upcoming meeting. The employee has submitted a request to join us into closed session. Technically, the Brown Act allows the employee to have the matter out in open session. However, some boards find it are amenable to just inviting that individual employee to come into closed session to hear the discussion and sit in for that conversation, while others are, strictly comply with the Brown Act, and what they do is they say, okay, we're just going to have the entire discussion had in open session so the employee can hear what's going on, and then from there on they will then convene into closed session to actually take action on that particular item.
So it's interesting, when these situations arise, it's usually the employee who is unilaterally requesting that the matter be considered an open session, not knowing completely what that entails. And so oftentimes in the districts that I work with, I will recommend that the superintendent notify the union president or some other labor representative that, hey, this employee has requested this to be done in open session. And usually it facilitates a good conversation between the union president and the employee, where the union president will explain what the ramifications of that might be, that their dirty laundry is going to be aired in public. And that will either lead to the withdrawal of the request. Because the confusion with this section is that it's a level of due process that the employees have. It's for their effectively a part of a hearing. But with school district employees, they have additional layers of due process that they may not fully understand. And so they think that this is their last opportunity. And so typically, In most cases, the request will be withdrawn. However, I have had situations where an employee wanted to address the board, and at the union representative's encouragement, the employee said, okay, I will agree to have the board hear me in closed session. I've been invited into closed session. I'll go present to them. The employee will speak to the board, and then the board will have that employee step outside while the board considers the matter behind closed doors privately. So that's usually what happens. On the rare occasion I've had it done in open session.
So if you do come upon a request from one of your employees to have a matter heard in open session, please make sure you consult with legal counsel on how the steps, how that can be done, what steps to take, what options they have to ensure that you're complying with the Brown Act. So public employee evaluation and disciplinary matters in closed session. You're allowed to have these discussions concerning any personnel matter related to evaluations and discipline. The title typically is going to either be Public Employee Performance Evaluation, and within that title on the agenda, you will need to specify the position of the employee being reviewed. You don't have to put the employee's name, of course, for confidentiality, or a lot of districts will put the employee ID number or something, but it should say Public Employee Performance Evaluation Principal or Certificated Employee or something like that. Another item for the agenda can be Public Employee Discipline Dismissal Release under the government code, and nothing else is required to be fleshed out there, nothing more specific there for that particular item. No additional information is required to put that there. However, some boards I do know will include employee ID numbers. Not very many. I think I've seen kind of a decrease in agendas that have employee number 1, 2, 3, 4, 5 included on the agenda.
And that's a great point, because if they put an employee number on there, it limits them to being only able to discuss that one item. And if an issue arises, let's say an unfortunate situation where a teacher is arrested for misconduct, between when the agenda is posted and when the meeting takes place, and you don't have that employee's ID number on there as well, you wouldn't be able to talk about that issue at that board meeting. However, if you just use the safe harbor language without, you're saying that would be okay, right? And they could discuss any employment issue related to public employee discipline dismissal release.
So keeping it broad as public employee discipline dismissal release without including specific employee ID numbers or titles gives boards flexibility to talk about additional or several employment disciplinary matters that are maybe pending.
And boards can have legal counsel in closed session under this agenda item, correct?
That's correct.
They don't have to separately agendize conference with legal counsel. So this does allow boards to have a legal counsel present, even if you don't have conference with legal counsel anticipated litigation agendized. So.
That's correct. So typically, if you have your legal counsel assisting with a particular employee disciplinary matter, they can join you into closed session to discuss that particular item. Okay, so another employment type matter in closed session would be public employee evaluations. The evaluation will extend to all employer considerations of an employee's discharge of their job duties after they're employed, including any time between their employment and their dismissal. So this agenda item can be used to discuss formal evaluations. It can be used to discuss informal evaluations. Just overall, how is the employee doing? Maybe there's something that has come about where the board has interest in talking about it with respect to a particular employee. But maybe it's not related to their formal evaluation. It's basically to discuss an employee's job performance while they're on the job, maybe to review particular instances of maybe their job performance. It doesn't have to be a comprehensive review of a particular employee's job performance. And then closed session, labor negotiations. So a board may meet in closed session with its designated representative regarding salaries, salary schedules, benefits, etc., or any other matter within the scope of negotiations for represented and unrepresented employees. So that does include executive cabinet employees, for instance, your superintendent, your CBOs, their unrepresented employees. You could discuss their salaries and salary schedules and benefits, et cetera, in closed session under this item for conference with labor negotiator, unrepresented employees. So you would need to designate that there. The closed session for labor negotiations may include discussion of an agency's available funding and funding priorities. You can also use closed session for labor negotiations. Shall not include, though, final action on the proposed compensation of the employee. So as we discussed before, there can be a discussion in closed session of the general parameters for the salary and benefits, but not in closed session to approve the contract or the specifics of the contract of the particular employee involved, correct?
That's correct. And I think it's really important to highlight with these last two closed session items that you've talked about, the public employee evaluation and this one with respect to labor negotiations. These two items have a tendency to lend themselves to the abuse of the closed session process because of the really broad topics that can be discussed. You can talk about the budget under the labor negotiations provision, and that can really lead to a meandering discussion about things and really take things off course. So when you're sitting in closed session having these discussions, work really hard as a collective group to keep the conversation limited and focused as best as possible, and to not begin to talk about, what budget line items are we going to use to, fund new technology for our elementary schools.
Okay, so litigation and advice of counsel for closed session. So a board may meet in closed session to confer with or receive advice from their legal counsel regarding any pending litigation matters. When discussion in open session would actually prejudice the position of the district. So we don't want the board to have to, in open session, talk about litigation strategy or maybe the nature of the litigation, because then it's out in the public, and then maybe it would, prejudice them in the actual litigation from being able to successfully defend or litigate a particular matter. So the board must state on the agenda or publicly announce at the meeting the authority for the closed session, and when known, the title of the actual litigation case. Typically, a board will put it on the agenda, conference with legal counsel, anticipated litigation, or pending litigation, and then we'll provide the specifics there. So under the Brown Act, litigation is pending when proceedings before a court are actually commenced, have been initiated before a court or administrative body or a hearing officer have actually begun, or based on the existing facts and circumstances, there's significant exposure to litigation. So no filing of a lawsuit or an administrative matter just yet, but there is significant exposure. And then also we're deciding whether to initiate litigation. So if the board has to discuss and decide, do we want to actually initiate litigation against a particular entity or an individual, that is also permissible in closed session. So significant exposure to litigation is dependent, of course, upon the facts and circumstances. So and this will have to be designated on the agenda as well. So where there's facts and circumstances that are leading to litigation which may not be known by the potential plaintiff, those facts and circumstances do not need to be disclosed on the agenda. So this is something where the board becomes aware that there's some exposure to potential liability, where they're not sure whether the plaintiff or potential plaintiff is aware of those facts. So so at that point, it's more up in the air, but there is some sort of exposure. You want to consult with your legal counsel in closed session about that. On the agenda, you will not have to specify the facts and circumstances of that potential exposure. There are circumstances where the facts and circumstances of the litigation are known to the potential plaintiff. And if that's the case, or there's a potential plaintiff who is aware of this potential liability, those facts and circumstances do have to be publicly stated on the agenda or announced, which, like I said, typically it's on the agenda there. So it will say something like conference with legal counsel, pending litigation or anticipated litigation, something like facts and circumstances, and you'll have to state what those facts and circumstances are on the agenda. So something like real property, premises liability, something like that on the agenda. The next item will be where there's a receipt of an actual government liability claim or other writing threatening litigation, and that's also that has to be publicly available for public inspection, and you'll also need to specify the type of litigation, like for instance, like discrimination complaint or something like that. Something specific enough for the public to understand what the nature of the liability is, or the litigation may be. A statement made in public threatening litigation, that's also enough to have the matter put into closed session to discuss that litigation. And then finally, a statement threatening litigation outside of a public meeting for which there is a contemporaneous record that is made available for public inspection. So these are the circumstances where a board may agendize to go into closed session to discuss anticipated litigation where there's significant exposure to litigation based upon the facts and circumstances. And so depending on the facts and circumstances, the agenda will need to include certain items or maybe not include certain items. And so we do recommend that if that is the case, that you consult with your legal counsel to make sure that your agenda item is specific and compliant with the Brown Act. Okay, so after closed session, once the board reconvenes into open session, they need to make sure, if let's say they take a vote into closed session, they need to make sure that the vote is recorded, and that way when they reconvene into open session, the individual votes of each member is actually read out into the public in open session, unless it's unanimous. So it would say board member 1 voted yay, board member 2 voted yay, board member 3 voted nay, and then of course if there's any abstentions, you'll have to actually designate that as well, so that the members of the public know what the board voted and how each individual board member voted on a particular item in closed session. These reports may be made orally or in writing. They're typically orally stated right after reconvening into open session, after leaving closed session. And then any documents that are referred to in a report of final action, from closed session must be made available on the next business day following the meeting, or in the case of substantial amendments, any necessary rewriting is complete. One thing to note, though, is that closed session matters are confidential, so the conversations and the discussions that occur in closed session must remain confidential. However, the vote and how each individual board member voted on the item, that is publicly available. So some reporting out requirements. So if there's approval given to legal counsel to settle pending litigation, and at any stage prior to or during the judicial or quasi-judicial proceeding, that needs to be reported out after the settlement is final. So there's a different process depending on where you're at in the settlement. So if you have an agreement from the other side and the board is simply accepting the settlement offer that's already signed and agreed upon by the opposing party, then the board will report its acceptance of that settlement, identify the substance of the agreement in open session at the meeting, and then during which the closed session is held. So they'll consider it in closed session. They're basically accepting the terms from the other party. They have signatures there. They're just going to report out the substance of the agreement. Okay, so for personnel actions taken in closed session related to personnel type matters, disciplinary matters, etc., any action taken related to the resignation or anything affecting the employment status of an employee of the district in closed session needs to be reported out in open session. The report must have the title of the individual employee. So for instance, it would be custodian. Typically, the readout will have the employee's ID number usually, so it'll say dismissal of custodian 1, 2, 3, 4, 5 or something in reading out in open session. The individual votes of the board members must also be read out in open session, so it will say, by vote of 4-1 with members 1, 2, A, B, C, D voting yay, member 5 voting nay to dismiss custodian employee ID number 1, 2, 3, 4, 5. That's typically the readout requirement when you're related to personnel matters that are taken action in closed session.
So one of the questions we get pretty frequently is, what can board members say? Who can they talk with? Some of this is a little bit of a review of the serial communications discussion that we had earlier, but there are some more specific examples in here that do discuss some of the limitations that board members have in their capacities as board members. So as a review, superintendent board communications, one-way communications from the superintendent to the board are okay. It's when you start to get into to the entire board when there's two-way communications. If, for example, if there's a reply all to a superintendent email, that's problematic. It's also okay for a superintendent to meet one-on-one with individual board members. Where it becomes problematic is if the superintendent shares the position of other board members with those individual board members. That's where it can become a problem. But it is okay for a superintendent to meet with individual board members. One situation where it comes up frequently is prior to a board meeting. Some superintendents will meet one-on-one with each individual board member to go over the agenda, to answer any questions the board member may have about any of the agenda items in an attempt to perhaps streamline the meeting or to resolve a potential issue of conflict. So those types of communications are okay. Just always remember, it's when additional information is shared that it starts to become problematic. Be mindful that any written communications created, so an email from board member A to the superintendent, is likely going to be a public record. There may be an exemption where that written communication would not be subject to disclosure, but it's very likely going to be disclosable as a public record. So be mindful of your written communications, not only using district email, but also using individual personal devices to send text messages and things like that. Because of the San Jose Court of Appeal decision from a couple of years ago, that information is actually accessible in a request for public records. So be mindful of your written communications. With respect to communications between individual board members, it's okay for two board members to have a conversation with each other about matters that are within the subject matter jurisdiction of the board. It becomes a problem when a third board member becomes involved in that conversation, because that creates that quorum. So even if board member 1 and 2 are having a private conversation about a matter within the subject matter jurisdiction of the board, that's okay. But if board member 1 then goes and meets with board member 4 and shares what the conversation was between board members 1 and 2 was, that becomes a potential serial meeting, and so you want to make sure you avoid that. And then anytime you're in public, you want to avoid the appearance of serial meetings, so it's okay to be gathered, as we talked about earlier, in those ceremonial events. However, if you're huddled in the back of the room and there's 3 of you on a 5-member board that are together, that could give the appearance that something inappropriate is happening, and that just heightens the level of scrutiny that you have on you and could potentially subject you to a Brown Act enforcement matter that we'll discuss in just a little bit. And it's okay to attend social events. So, if you're going to a graduation party and all 3 of these particular board members happen to know the person and the family that is holding the graduation party, it's okay to attend that meeting, but avoid quorums if possible. Like if 3 of you get invited, you may want to have a discussion amongst each other about when you're going to attend the meeting so that 3 of you aren't there at the same time. And if you are all there at the same time and there's 50 people there, try to avoid clustering together as the 3 of you. When you're thinking about what you can communicate to the public, that's a really important consideration, because as an elected official, the public is going to reach out to you and you have the ability to reach back. But you want to be mindful of your board bylaws when you're having those communications, because Your previous boards have adopted bylaws that may place some limitations on what types of communications you can have, or at least put some fence posts around those communications. And so anytime a member of the public comes to you as an individual board member and says, I have a problem with ABC school, and I'm concerned about this particular teacher and what they're doing, your immediate response should obviously be empathy. I'm sorry that that's happening. What I'm going to do is I'm going to recommend that you speak with Assistant Superintendent Brooke Jimenez in our HR department. She can help you, or she can refer you to one of her directors, and I will let her know that you're going to be contacting them. That would be the extent of the communication with that member of the public on that concern that I would recommend. In your capacity as a board member, your board bylaws do generally prohibit board members from serving administrative functions. When you look at your board bylaws, it's just pretty much across the board. Boards are referred to as policy-making bodies. You set the vision for the district. You set the direction for the district going into the future. But a board is not expected to manage the day-to-day operations of a school district. And individual board members don't have any authority to handle the day-to-day operations of a school district. The board only acts as a collective body, and it takes a majority of the board to take action. So if only 2 board members on a 5-member board want to do something, the board itself is not going to take action until a 3rd member jumps on and agrees that that action should be taken. So individual board members don't have any individual authority to perform any sort of administrative functions. And so that's why it's important that if a community member complains to you about something, raises a concern, that your first response is empathy, your second response is to refer them to the right person and leave it at that, and let the day-to-day operators of the district handle the issue. And I'm sure if it's an issue that rises to a substantial level, the board is going to get an update on that. So be looking, if you're a new board member, look at your board bylaws to familiarize yourself with kind of the parameters that previous boards have established for the board, and establish what its appropriate roles are. And if you have a question, ask your superintendent. And if you have a board president who's been on the board for a long time, ask your board president, is it appropriate for me to do X, Y, or Z? And the board president may know the answer. The board president may say, I'm not sure, speak to the superintendent. And that's important. And we talked about social media as well. It's not effective to govern using social media. And as the Brown Act amendments, the recent ones that we discussed earlier in the presentation have made clear, it's unlawful to be engaging in those discussions about issues within the subject matter jurisdiction of the board on social media, especially when it involves additional board members just beyond yourself. So be mindful of that, and try to keep your communications limited to listening, to getting ideas from your constituents and things like that you may want to share with your superintendent, but leaving the administrative functions, the investigations, the look into X, Y, or Z, leave that to the people that are running the day-to-day operations of the district. You're also going to receive communications from your labor associations. The representatives for the teachers are going to communicate with you, and the representative from your classified employees are going to speak with you, and that's great. They're your constituents as well. But when it comes to labor negotiations, it's important to remember that their positions may not reflect the positions of the district. And so as an individual board member, it's okay to receive their feedback. The teachers may say, hey, we think that class sizes should be smaller, and you can listen to that. And you can ask them questions. Why do you think that? What's going on? But we don't recommend for a number of reasons, the most important of which is negotiation strategy is discussed in closed session and it's a violation to share that information. That's the primary consideration. But we don't recommend sharing that information also because it could disadvantage your designated bargaining team at the table. And if a majority of the board has directed them to act in such a way and that strategy gets out, it could undermine them when they're engaged in negotiations, which in turn would undermine the majority of the board's direction for bargaining. And we want to avoid that because, again, the board acts as a collective, not as individuals. So those are communications. When you're thinking about what can you do as a board member, as I mentioned just a second ago, the most important thing you can't do is you cannot disclose confidential information received in closed session. So if you're wondering what confidential information is, just think about it. If you received it in closed session, it's confidential. And the only reason you could share it is if a majority of the board agreed and consented to that information being shared outside of closed session. And the Brown Act does provide for certain criminal and civil penalties if you share information from closed session without appropriate authorization. So it's really, really important. Those closed session conversations are to remain confidential. And if you're new to the board and you've never really been kind of under that kind of confidentiality obligation before, it's tough getting used to. But if somebody says, oh, what'd you talk about tonight? Keep it limited to what was discussed in open session and don't bring up any major issues or any issues at all that happen in closed session. That can become really challenging if there's a big issue that hits the newspapers or the news media in some way, and you have a conversation about that in closed session with your other board members and with the superintendent and with legal counsel perhaps. People are going to know about a major issue that's impacting the school district, and you're going to have more information than they do, but you can't share that information. You learned it in closed session, and you need to keep it confidential and respect that confidentiality. So those are the things you can't do. With respect to things you can do, it's important to refer to your board bylaws. Individual board members, we talked about, they have limited authority. They have the same rights and powers as any individual member of the public. So an individual board member, just by virtue of being elected, does not gain additional authority to, for example, direct staff to do something. So an individual board member cannot walk onto a school district campus, for example, and tell the principal to meet with you for 3 hours and have 5 or 6 teachers come into the meeting so that you can poll them on various issues. That is not something that you can do. Similarly, if you are preparing something for a board member comment at a meeting that's coming up and you want to have a visual prepared for that, you cannot direct district staff to prepare that visual for you. That you're going to need to take care of that on your own, in your own individual capacity. So just be mindful of that there are limitations on a board member's authority. We have some hypotheticals in just a little bit where we can discuss those a little further. The only person who may have a little bit of additional authority or additional power is the board president. And that board president gets their additional powers by virtue of the board bylaws. Typical board bylaws state that the board president is the spokesperson for the board. That's one of their additional powers. And so if an issue impacts the school district, the only person who has the authority to speak on behalf of the board is the board president. So most board bylaws will require other non-board president board members to make sure that they, in their public statements, make it clear that they are not speaking on behalf of the board, for the board, or expressing the board's opinion in any way. So if you have a social media page, you need to make clear, if you're not the board president, that you are expressing your own opinions and these are not the opinions of my fellow board members and I'm not speaking on behalf of the board. That is a requirement in board bylaws, In some districts, violations, continued violations of those bylaws may result in a public censure or some other consequence that the bylaws may provide for. You also have, if you're the board president, you have the authority under your bylaws to set the agenda and to preside over meetings. And typically what the setting of the agenda means is the board president and the superintendent will get together and they will prepare the agenda for the upcoming board meeting. And the board president will say that this looks good. The board president does have the discretion to say, no, let's not do this at this upcoming board meeting. Let's wait for a later board meeting. And so the board president does have that authority. And then to preside over board meetings, the board president, they'll be handling the gavel at the board meeting. They will be reading off what agenda items are coming up, and calling for motions, keeping order, those types of things. So those are some of the additional powers. And then finally, board presidents under the board bylaws have the authority to engage legal counsel. And that authority is necessary, and it only comes up sometimes, but if there's a concern about the superintendent, for example, the board president may need to speak with legal counsel without the superintendent knowing, so that the board can receive legal advice on how to address that concern. And so the board bylaws do allow the board president to contact legal counsel. Most board bylaws that I have dealt with, and I'm not sure if your experience has been the same, but most board bylaws do limit that ability to contact legal counsel to just the board president, and other board members don't have the authority to contact legal counsel unless that authority has been delegated to them by a majority of the board. Is that consistent?
Yeah.
Yeah. So after COVID-19, there are some norms that are going to be restored as the public health situation improves. So do you want to address some of those changes?
Yeah, so we're talking about after COVID-19, whenever that may be, but we do know that there's been an increase in more in-person meetings, even in the last 6 months or so, especially for this current school year. And so effective October 1st, 2021, the executive orders that were passed in March 2020 will then expire. And so the flexibility regarding teleconferencing and public access, through virtual means, that will be expiring as of September 30th. So the rule will remain the same in terms of allowing public access in person after October 1st. So that will need to be required by your boards. The flexibility for governing board or body members to receive updates relevant to COVID, that will expire as well. So the ability of the board as a whole to sit down and hear and ask questions of state, local, or federal officials concerning COVID-19, that's also going to expire. And then after September 30th, basically you're just going to revert to your traditional in-person Brown Act rules, unless there's some upcoming legislation that is passed between now and September 30th. So we are going to be keeping our eyes out for, especially at the September 15th date, to see if there's any extension of the previous COVID executive orders, or maybe some modification, or maybe some new legislation. There's a number of new assembly bills that are kind of pending in the legislature that we are keeping an eye on, and we have those listed here. So specifically, the following rules will be restored as of October 1st. So all meetings of the board need to be in open and public, and all persons shall be permitted to attend in person. That will be restored. The requirement to give notice of each teleconference location from which a particular member of the board is participating by teleconference, so that person can participate. For instance, the requirement that their location be specified on the agenda, the requirement that the agenda be posted at their particular teleconference location, and the requirement that members of the public may actually access that particular teleconferencing location. Those rules will be restored as well as of October. In addition, the requirement that each teleconference location be accessible to the public, like I said, requirement that members of the public may address the body at each location, requirement that at least one member of the board be physically present at the meeting location. That rule will be reinstated as well. And then the requirement that during a teleconference meeting, at least a quorum of the board must participate within the boundaries of the districts. And so those, the regular rules are going to be reinstated where we need to at least have a quorum within the boundaries. All of the other additional posting requirements if a member is going to be participating outside via teleconference. So one thing to note and recommendations that we've been providing is just to reset your norms after COVID. Once those rules are, the executive orders expire and you have your in-person rules reinstated, it's good to remind members of the public of the rules and policies for making public comments. It's good to remind them about meeting decorum, in-person decorum, disruptions, etc. It's good to remind them again of the rules for placing items on the agenda and how they can do that. It's also important to ensure that your agendas are physically and electronically posted, and that they're ADA accessible. So if you need to have that sign language interpreter present again in person during an in-person meeting, you need to make sure that that's arranged. It's also important to enforce any remaining safety or public health orders. So, we're saying after COVID-19. So if there are some lingering or additional kind of health and safety requirements, make sure those are being enforced for in-person attendance as well.
With respect to enforcement, we talked about potential problems that can arise under the Brown Act if you share information that you learned in closed session without authorization, or if the board itself as a whole violates the Brown Act in some way. There are some enforcement measures. There's civil enforcement measures, and those typically are court actions such as an injunction to stop a board action from taking place, or a writ that can be a potential nullification of a board action. Those are court actions. There's administrative remedies such as the cure and correct remedy, where an individual will say in a letter that you violated the Brown Act when you did X, Y, or Z. I demand that you take action to fix what you did and do it in compliance with the Brown Act. And if you fail to take action appropriately and you're taken to court, there can be some attorney's fees awards if those actions aren't properly taken. And then there's also criminal potential enforcement actions. If you intentionally and knowingly violate the Brown Act, you could be guilty of a misdemeanor. However, if you take action if you take action in reliance, good faith reliance on the opinion of legal counsel, that may preclude that intent element and allow you to escape criminal liability if something was to happen. So there are two mechanisms for enforcement, two kind of legal mechanisms for enforcement. The statute under Government Code Section 54957 spells out the consequences for a board member that takes action with the intent to deprive the public of information to which the member knows or has reason to know the public is entitled is guilty of a misdemeanor. So these would be individual consequences for violating the Brown Act. And then we talk about serial meetings and things like that, and how the definition of action and communication has been expanded over time. The Attorney General has opined on this issue that action taken is defined to include the collective commitment. Mere deliberation of some action will not necessarily trigger a criminal penalty. So if you are knowingly engaged in a violation of the Brown Act and you actually reach a collective agreement to take some sort of action outside of a noticed board meeting, that could be a subject of the criminal penalty, but that would be, again, the district attorney's office would need to do some inquiry on that. And again, good faith reliance on opinion of counsel generally will insulate a school board from that intent issue. Again, we're not going to belabor this issue. There's no violation of the confidentiality of closed session. Please do not share information that you learn in closed session. That's a specific prohibition in the Brown Act, and we really hope that that's taken to heart, because it's very serious to keep that confidentiality. There's privacy issues at stake when you're talking about individual employees. You're also learning confidential information about students in closed session. So not only do you have the Brown Act prohibitions on sharing confidential information, the students' information that you receive would be covered under the federal FERPA laws and also the state student privacy laws. And so it could be multiple legal concerns if information that is learned in closed session about a student is shared outside of that venue. So just one more time, we strongly encourage you, please do not share information that you learn in closed session. What the idea here is that we want you to avoid any sort of concern that the Brown Act is being violated, because it's expensive to litigate these issues. Your compliance should be as tight as possible so that you never find yourself facing one of these challenges. All right, I think at this point we have some time for some questions, so we're happy to take those.
My name is Jesus Holguin. I am the clerk with the Moreno Valley Unified School District Governing Board. And my question is this: how do Robert's Rules of Order apply to a meeting that falls under the Brown Act? And also, if we want to add something to the agenda, can't we just do it right before the meeting starts?
Great question. I'll take the second question first. With respect to late additions to the agenda, those can only be made in an emergency situation, and it has to be an actual emergency. It can't just be, oh, we forgot to put something on the agenda. It has to be, the issue is of such an urgent concern that if the board fails to take action on it at that meeting, there will be some sort of detrimental consequence to the board. And in order to make that change to the agenda in an emergency basis, it has to be approved by a 2/3 majority of the board. So if you're thinking of a 5-member board, in order to reach that 2/3 threshold, you'll actually need 4 board members to vote on that to approve the amendment. We always recommend that you contact legal counsel if there is a belief that you need to make an emergency amendment to the agenda, so that the legal counsel can walk through the issues with you and the superintendent to make sure that if the amendment needs to be made, that it is an appropriate circumstance for that to happen.
Yeah, the need for the emergency, or the emergency needs to arise within the period after the agenda has already been posted as well.
Yeah.
So it, rather than, oh, we simply forgot, it needs to be a situation that falls within the 72-hour or 24-hour period if it's a special meeting that they couldn't anticipate, but immediate action needs to be taken, otherwise the district will suffer some detriment.
The other question asked about Robert's Rules of Order. Robert's Rules of Order is not referenced anywhere in the Brown Act, so it is not governed by the Brown Act. It's a procedural method that was established long ago for the conducting of business in legislative bodies such as the British Parliament, such as the United States Senate, and there's a number of variations of Robert's Rules of Order. There's if you were to say we should follow Robert's Rules of Order as a board, and you were to actually look into Robert's Rules of Order, you would find that it's a voluminous document. There are a lot of procedural issues that really are not practical for school boards in how they conduct their business. So some school boards have, in fact, adopted into their board bylaws under their meeting conduct provision, I believe it's 9323 in most school districts, they've adopted that they will use Robert's Rules of Order for their procedural guidance in the school board meeting. However, I've been to hundreds of school board meetings in my career, and there has never been a school board that follows Robert's Rules of Order with fidelity. It is, and that's not a slight on any school district. again, it's an extremely complicated body of procedural rules. There are rules in there that are just so arcane and for such a limited purpose that it doesn't make sense. So a board president, within the meeting conduct and within their delegation of authority within the board bylaws, has the authority to run a school board meeting. And so typically it's going to be the board president that ultimately sets the kind of the procedural tone for how a school district takes up a motion, does a discussion, calls for a vote, all that sort of stuff. You may have Robert's Rules of Order in your school district, and it's good to try to use some of the Robert's Rules of Order techniques to keep your board meeting flowing in an organized and orderly way. However, an expectation that Robert's Rules of Order be followed in the strictest possible way is unreasonable and probably would lead to very lengthy school board meetings.
Hi, this is Mary again. I have a question. What can I, as an individual board member, do to address concerns raised by district employees, students, or community members?
Excellent question. And that goes back to the discussion about the board bylaws and how they govern the conduct and the authority of individual board members. You have to remember the default under the education code is that the board only acts as a collective body, meaning there is no board action unless the majority of the board takes action. So individual board members don't have any authority in their individual capacities to resolve complaints, concerns, and things of that nature. So the best course of action as a board member is to listen to a complaint, listen to a concern of a parent, be empathetic, and similarly to an employee, be empathetic, but at the end, know the resources that your school district administration has available to it and direct that individual to those resources. So if it's a parent that has a concern about special education, for example, listen to that concern, tell the person, thank you for sharing, here's the person that you should speak with, and I will send the superintendent of communication to let him or her know that you're going to be contacting the special education department. Similarly, if it's an employee complaining about something, direct the employee to speak to the assistant superintendent of human resources, let them know, thank you for sharing your concern, and I will let the assistant superintendent of HR know that you're going to be contacting them. But as an individual board member, you don't have the authority to resolve a complaint or to investigate a complaint. That's handled through the day-to-day operators of your district and the administrative team.
Hi, I'm Kathy Thompson from Central School District, and I have a question. When I'm walking around school sites, can I direct a site principal to make changes to how he or she is operating the school site?
So, as discussed previously, individual board members do not hold any individual authority. The board acts as a whole, through majority, and individual board members and even the board as a whole do not have the authority to direct a particular employee to take any sort of action. So, board member may not, go onto a school site and direct the work of the principal or other employees at the site. But what they could do is, in an open session amongst the board, discuss some changes they'd like to see or some concerns or some things of that nature that they would like to see in terms of the educational program or maybe something related to the school site there. That would be the appropriate venue. But they have limited authority when it comes to directing the work of the employees of the district.
And I also think that individual board member, if they see a concern at a school site, would be better off talking to the superintendent about that concern, not even trying to pull the principal aside, because again, just by the mere act of pulling the principal aside, you may be directing that person in a way that is not consistent with his or her job duties at that school site. So you're better off, if you have a concern at a school site, taking that concern to the superintendent or the assistant superintendent of ed services and letting the day-to-day operators of the school district handle that concern.
Hi, thanks for the opportunity to ask a question. This is Karen Gray from Silver Valley Unified. What is the best way for boards to handle a superintendent's contract during closed session?
Superintendent contracts can be discussed in closed session. Bear in mind that they can only be discussed in closed session at a regular board meeting. They can't be discussed at a special board meeting. So we have to kind of set that ground rule first. Superintendent contracts can be discussed in closed session under the conference with labor negotiator, unrepresented employee, closed session agenda item, the safe harbor language. And you can discuss, what salary you want to offer the superintendent, what fringe benefits you want to offer the superintendent, what any termination provisions within the contract might be included. So you can discuss the entire contract, but you cannot take action to approve that contract in closed session. That has to be done in open session. So think of it in terms of negotiations. The closed session allowance to discuss the superintendent contract should be part of the negotiations process when you're thinking about the superintendent's contract. You're either in closed session to hear from your search consultant for a superintendent that this is what the superintendent is asking for, and you listen to that and you say, well, I don't think we're, as a collective board, prepared to offer that salary, but we would be willing to offer this salary, so you can go back and communicate to the candidate that this is what we'd like to offer. If you have an existing superintendent and you're not doing a search, you could have a closed session discussion about a potential contract amendment for your existing superintendent to provide that individual with a salary increase. But again, the thing to be really mindful of is that the approval of that contract has to happen in open session and can only happen after there's been a public readout of the salient terms in that contract, specifically related to compensation, fringe benefits, and things of that nature. So your open session report would want to say something to the effect of, the board is considering a superintendent's contract in which the superintendent will have a 3-year term or a 4-year term. The superintendent's salary in year 1, which is stated in the contract, will be X dollars. The superintendent will receive the same health and welfare benefits as all other management employees, and the superintendent will receive $500 a month for a car allowance. And then once that announcement is made, the board could then go into discussion and deliberation in open session about approving that contract. So those are the ground rules for discussing a superintendent's contract in closed session. And I think that question, and I think the resulting answer, reinforces the real main point of the Brown Act that we discussed at the very beginning of this presentation, that the Brown Act is intended to allow the public to be observers of the board conducting its business. The intent behind the Brown Act is for all the school's business to be conducted in open, out in the light of day, with very few limited exceptions. And so we hope that the information that you gathered today will help you kind of stay within those boundaries and help you in your day-to-day role as a school board member. Do you have any closing thoughts?
No, thank you for your time, and I hope you've enjoyed this presentation on the Brown Act. Of course, if you have any additional questions, we're always available. Thank you.
Thank you.
There you have it, the Brown Act. What you don't know can hurt you. On behalf of my office and the San Bernardino County School Boards Association, I want to thank our 2 attorneys and our partners at the Inland Personnel Council for this timely and appropriate training. Now we want to hear from you. What did you think of the presentation? Please take a few minutes to complete our evaluation in the description below. Your valuable feedback helps us to better plan for future events. We also have the slide deck available for download in the description below. Thanks again for joining us. Remember, together we will transform lives through education.